Wilma L. Zamora versus Atty. Makilito Mahinay, AZ number 14128, formerly CBD case number 19-6086, April 2, 2025, 3rd Division, Ponente, Justice Gaerlan. Complainant Wilma L. Zamora filed a disbarment case against Atty. Makilito Mahinay, counsel of the opposing party, in several intracorporate disputes involving EJH Lending Corporation. Zamora accused Mahinay of the following. Number 1. Forum shopping, by filing multiple pleadings and petitions seeking the same relief, suspension of criminal proceedings. Number 2. Abuse of court processes, filing repetitive motions and petitions for inhibition after adverse rulings. Number 3. Misleading the court, transmitting the court order to the NBI before the dissolution of a pending motion for reconsideration. Number 4. Unjust and unfair accusations against lawyers, accusing Zamora and her counsels in pleadings of plotting to assassinate him and distributing copies of such statements to judges. The IBP-CBD recommended admonition for abuse of process and 6-month suspension for unjust accusations. The IBP Board of Governors, or IBP-BOG, modified this, dismissing the other charges but maintaining the 6-month suspension. Mahinay filed a motion to reopen, claiming denial of due process and miscarriage of justice. So the issues in this case are, number 1, whether Atty. Mahinay is administratively liable for forum shopping, abuse of court processes, and making unjust accusations. The court held that yes to liability but no to denial of due process. Forum shopping and abuse of court processes. The court found Mahinay guilty of forum shopping since he filed multiple pleadings in different courts seeking the same relief, suspension of criminal cases pending intra-corporate disputes. He also abused court processes by repeatedly filing motions for inhibition whenever he received unfavorable rulings. Such conduct constitutes willful forum shopping and frivolous filings, prohibited under Canon 2, Section 23 and Canon 3, Section 7 of the CPRA. For unjust and unfair accusations, Mahinay's accusations that opposing counsel plotted to assassinate him were irrelevant to the case and not protected by privileged communication. His language violated Canon 2, Section 2 and 4 of the CPRA, requiring lawyers to act with civility and use dignified language. The second issue in this case is that whether there was a denial of due process warranting reopening the proceedings. The court held that no denial of due process. Mahinay was given full opportunity to be heard before the IBP, and there was no miscarriage of justice to justify reopening the case. Atty. Makilito Mahinay was found guilty of, number 1, willful and deliberate forum shopping, suspension from practice of law for 1 year, and then abuse of court processes, fine of 35,000 pesos, and last, unjust accusations and use of intemperate language, fine of 100,000 pesos. And he was warned that repetition of the same or similar acts shall be dealt with more severely. Thank you for watching. Like and subscribe for more case digests.